Question 581. Which of the following is considered an advantage of FHA loans over conventional loans? A. FHA loans usually have a higher loan-to-value (LTV) ratio than conventional loans. B. FHA loans do not have to be paid back until at least 4 years after the loan is made. C. FHA loans are more likely to have lower interest rates than conventional loans. D. Both A and C. Correct answer is D. Both A and C. Due to FHA loans' higher LTV, an FHA loan typically requires less cash put down at closing than with conventional loans. The FHA insurance reduces the lender's risk, which can translate to more favorable interest rates for the borrower compared to uninsured conventional loans, especially for those with less than perfect credit or smaller down payments. FHA loans have standard repayment terms, typically ranging from 15 to 30 years, with payments starting shortly after the loan is originated. Question 582. A long-time general rule of contracts states that a party's acceptance of an offer is effective upon dispatch, even before the acceptance is actually received by the other party. This is called the A. Effective dispatch rule, B. Acceptance timing, C. Mailbox rule, D. None of the above. Correct answer is C. Mailbox rule. Acceptance timing is a general term and doesn't specifically refer to the rule regarding the effectiveness of acceptance upon dispatch. Effective dispatch rule phrase accurately describes the concept, but mailbox rule is the more widely recognized term. The mailbox rule is a legal principle that states that an acceptance of an offer is effective upon proper dispatch even if it's delayed or never received by the offeror. The mailbox rule has been expanded to cover all technology by which commercial communication may reasonably be conducted, including telephone, email and fax. Question 583. A property's selling price appears on a buyer's closing statement as A. Debit to the buyer, B. Credit to the seller, C. Debit to the seller, D. Credit for the buyer. Correct answer is A. Debit to the buyer. The selling price represents money the buyer owes for the property. Therefore, it's recorded as a debit, which increases the amount the buyer needs to bring to closing. The selling price also represents money the seller will receive for the property. Therefore, it's recorded as a credit, which increases the amount the seller will net from the sale. So, the selling price appears as both a debit to the buyer and a credit to the seller on their respective closing statements. Question 584. The following state differences between a trust deed and a mortgage, except A. The party that holds the security, B. The way title is conveyed, C. The number of parties, D. Both B and C. Correct answer is A. The party that holds the security. In both a trust deed and a mortgage alike, the security is held by the lender. As for differences, a trust deed has bare legal title conveyed to the trustee, while a mortgage has title maintained by the borrower. Also, a trust deed has 3 parties, a mortgage has 2. Question 585. The document used in a business sale that is akin to a grant deed in the sale of a home is called A. Bill of sale, B. Deposit receipt, C. Business transfer statement, D. Bulk sales security agreement. Correct answer is A. Bill of sale. Deposit receipt is a preliminary agreement in a real estate transaction, outlining the terms of the offer and acceptance, along with the initial deposit. It's not the final conveyance document. In a business sale, there might be a similar preliminary agreement, but it wouldn't be called a deposit receipt in the same way. Business transfer statement isn't a standard term for the transfer of business ownership in the same way a bill of sale is for asset transfer or a grant deed is for real property. There might be documents with similar titles used in specific contexts, but bill of sale is the more common and direct equivalent. A bulk sales security agreement is related to the Uniform Commercial Code, UCC, and is used to secure a loan against the assets being sold in bulk. It doesn't primarily function to transfer ownership in the same way a bill of sale does. Grant deed, real property, is the primary legal instrument used to transfer ownership of real property, land and anything permanently attached to it, from the grantor, seller, to the grantee, buyer. It implies certain warranties from the grantor to the grantee. Bill of sale, personal property, business assets, is a legal document that transfers ownership of personal property from the seller to the buyer. In the context of a business sale, the majority of what's being transferred, inventory, equipment, furniture, fixtures, intellectual property, etc., is considered personal property, not real property, unless the sale includes the land and buildings. The bill of sale serves as the formal written evidence of this transfer of ownership of the business's assets, similar to how a grant deed transfers real property. Question 586. Upon an agent's disclosure of dual agency to the parties, if the parties consent to such an agency it must a. Be relayed to the state attorney's office, b. occur at least 30 days before the close of a transaction, c. disclosure of a dual agency is not required, d. be in writing. Correct answer is D. Be in writing. There is no requirement to report the consent to dual agency to the state attorney's office. The disclosure and consent are primarily between the agent and the principals, buyer and seller. The California Department of Real Estate, DRE, oversees real estate licensees, but routine dual agency consent isn't reported to the state attorney. While early disclosure is good practice, there isn't a specific requirement for the written consent to dual agency to occur at least 30 days before closing. It must happen before or at the time the parties enter into a contract. When an agent discloses dual agency, representing both the buyer and the seller in the same transaction, to all parties involved, their consent to this arrangement must be in writing. This requirement ensures that all parties understand the implications of dual agency and provide explicit, documented agreement to it. Question 587. The difference between the nominal rate of interest and the effective rate is a. The nominal interest rate is what is specified in the actual loan. The effective rate is what the borrower actually pays in interest. b. The nominal interest rate is specified in the actual loan. The effective rate is what borrowers are paying for a similar property. c. The nominal interest rate is the rate proposed by the borrower in negotiations with the lender. The effective rate is what the lender wants the borrower to pay. d. There is no difference between the nominal and effective rates. Correct answer is a. The nominal interest rate is what is specified in the actual loan. The effective rate is what the borrower actually pays in interest. Nominal interest rate is the stated or advertised interest rate on a loan. It's the rate written into the loan agreement. Effective interest rate is the actual rate the borrower pays when considering all the costs associated with the loan. It can differ from the nominal rate due to factors like 1. Compounding frequency. Interest compounded more frequently, e.g., monthly versus annually, results in a higher effective rate. 2. Fees and charges. Loan origination fees, discount points, and other charges increase the total cost of borrowing, thus raising the effective rate. 3. Prepaid interest. If interest is paid up front, the effective rate over the loan term can be higher. Question 588. An owner tells his listing agent that his home being sold, has a leaky roof. The listing agent should A. Tell the owner to paint over any water spots that indicate there is a leak. B. Disclose the fact that the roof leaks to prospective purchasers. C. Not disclose the fact that the roof leaks to prospective purchasers because it is not a material fact. D. Disclose the fact that the roof leaks to prospective purchasers only if the purchasers ask specifically about any problems with the roof. Correct answer is B. Disclose the fact that the roof leaks to prospective purchasers. Real estate agents in California have a fiduciary duty to their clients, the seller, but also a duty of honesty and fair dealing to all parties in a transaction, including prospective buyers. This includes disclosing all known material facts about the property that could affect its value or desirability. A leaky roof is undoubtedly a material fact. Selling a property, as is, does not relieve the seller or the agent of the duty to disclose known material defects. As is generally means the seller will not make repairs, but it doesn't negate the requirement for transparency about the property's condition. The duty to disclose known material facts exists regardless of whether the buyer asks specific questions. Agents cannot wait for buyers to stumble upon problems, they must proactively disclose known issues. Buyers still have the right to know what they are buying. Concealing a known leaky roof from a buyer can be seen as misrepresentation or even fraud. Paint over any water spots is unethical and potentially illegal. It's an attempt to conceal a known defect, which violates the agent's duty of honesty and fair dealing. If the buyer later discovers the undisclosed issue and proves the seller and agent were aware of it, they could face legal consequences for this lack of transparency. Question 589. The right of a utility company to string power lines across privately owned land is an example of A. Zoning ordinance. B. Eminent domain. C. Encumbrance. D. Condemnation. Correct answer is C. Encumbrance. Zoning ordinances regulate land use and development within a specific jurisdiction. They wouldn't directly address a utility company's right to install power lines. Eminent domain is the legal power of the government, or entities authorized by the government, to acquire private property for public use, often with just compensation to the owner. While eminent domain could be used to acquire land for power lines, it's not the term that describes the ongoing right of the utility company to use the land. Condemnation is the legal process by which the government exercises its power of eminent domain. Similar to eminent domain, it focuses on the acquisition of property, not the ongoing right to use it. Encumbrance is the most accurate answer. An encumbrance is a right or interest in a property that affects its ownership and limits what the owner can do with it. In this case, the utility company's right to have power lines on the property is an encumbrance on the private landowner's ownership. The landowner cannot completely exclude the utility company from the property for the purpose of maintaining the power lines. An easement in gross is an easement that is not created to benefit a particular parcel of land, but to benefit a specific user, in this case a power company. Easements in gross are in the larger category of encumbrances. Question 590. Broker Dolores sells a home listed by a broker from another brokerage. Her arrangement with the listing broker can be described as A. Selling broker. B. Third party. C. Co-agent. D. Principal. Correct answer is A. Selling broker. When a broker, like Dolores, from one brokerage finds a buyer for a property listed by another brokerage, they are acting as the selling broker or selling agent. They sell the property to their buyer client, even though they don't hold the listing agreement with the seller. They cooperate with the listing broker to facilitate the transaction. While Dolores is a third party to the listing agreement between the seller and the listing broker, this term doesn't specifically describe her role in the cooperative sale. A co-agent typically works for the same brokerage as the listing agent and assists in marketing and selling the property on behalf of that brokerage's client, the seller. Dolores works for a different brokerage. The principal in this scenario is the seller, who hired the listing broker, and the buyer, who hired Dolores, implicitly or explicitly through their working relationship. Dolores is acting as an agent for the buyer. Therefore, the most accurate description of broker Dolores in this situation is a selling broker or a cooperating broker.